Hey everyone, it's Rob Ryder. It's Thursday after Easter 2012. Don't remember the exact date. I remember Easter because I try to do this on Easter, this particular video, and for some reason it won't upload. But ones have after, so I don't think they're messing around. I think the creator wanted me to say something else. So I'll hope I catch it this time. So this is out of Florida. 2005 Florida Code, real and personal property, assignment, and cancellation of mortgages. All right, well, we want to cancel a mortgage. And the hyperlink will take you to where I found it. And then, this is just what you're looking at now, or what, after I've copied and pasted it onto a Word document and start tearing it apart. But the main thing on here is, let's just look at what it says in Chapter 701. Well, you're going to talk about an assignment, and then assignment not effectual against creditors unless recorded and indicated in a title of document, and its applicability. So an assignment isn't effectual against creditors. I wonder who the creditors are, unless it's recorded and indicated in the title of the document. It'd be good to know what that is. Then we have the cancellation. We're talking cancellation of mortgages. Cancellation of mortgages, liens, and judgments. Well, guess what? Mortgages, liens, and judgments are all the same thing. Then you got a title insurer and a thing called a mortgage release certificate. And then certain cancellations and satisfactions of mortgages validated. Right? So not only will it be canceled, the cancellation will be validated. So I'm not going to spend a lot of time on this one, but what we really probably spend a little more time on is this right here. Now I included this document and did a breakdown on it on another video that you see at the top of this piece of paper. And this is what the mortgage is. All right, it's no more, no less. If you don't understand this when I get done saying it, walk out of the room, get a cup of coffee, Coke, whatever it is, your beverage of choice, walk back in and read it again, because this is as simple as it can be. An equitable mortgage of lands is one where the mortgagor does not convey regularly the land, but does some act by which he manifests his determination to bind the same for security of a debt he owes. Okay, so an equitable mortgage of lands is where the mortgagor does not convey regularly the land. Well, if you're going to regularly convey the land, you would do it on a deed, and that deed would have on it you as a witness, because it's going to say sealed behind your name. Now we're talking about you being the grantor, right? So we're going to be talking about deeds of trust and the escrow. But think about it as the land deed for just a second, and then get it out of your head, because we're not going to be talking about the land deeds very much, which would be the grant deed, warranty deed, whatever they call it where you're at. So to convey it regularly, you would do it on a warranty deed, right? And you would have the grantor seals it. It goes to a notary for an acknowledgement from her, and then the court's going to put their seal on it. And, in that case, the court is the registered deeds, because they're part of the court. Okay? So you haven't done it that way. So it's not recorded like your property record is of the house you live in, where that grantor did it regularly, and now it's in that record. But does some act by which he manifests his determination. Well, you did your free will act and deed when you signed a deed of trust. And you put down on there what the security was going to be. And it included not only the real estate of the warranty deed, so it doesn't matter if you own that or not, even if you've acknowledged it, you put it down on a deed of trust, mortgage, security of whatever kind, as security for the mortgage. And also your security payments that go into the escrow account. They're only there until you satisfy the mortgage. Well, what's the mortgage? All right, because since it wasn't a contract between you and the bank, they didn't lend you any money. an agreement in writing to transfer an estate as security for repayment of sum of money borrowed, or even a deposit of title deeds, and a verbal agreement will have the same effect as creating an equitable mortgage. So you can create an equitable mortgage by merely allowing somebody to frickin' deposit the title deed and give a verbal agreement. You know? Now, do you think they stood there and said, hey, we're going to do this verbal agreement with you right now, and you're going to deposit this and cause an equitable mortgage? I don't think so. But by the definition of Bouvier's, that's all it takes to give them an equitable mortgage. Because when you deposit something with somebody, which is the same as file or register, all those have the same meaning. When you deposit something with somebody, they get an equitable mortgage, therefore legal title over the property. But only until the mortgage is satisfied. Well, it wasn't done as a contract because the bank never signed it. They never acknowledged it, so they never lent you any money. So it can merely only be because there's shit been deposited and you've agreed to it. And I'm not going to go through all these, but just the highlights. So where does establish the rule that the mortgagee, that's them, holds the estate merely as a pledge or security for the repayment of his money. Again, they didn't lend you any money. It never says on your deed of trust they lent you any money. It may say something to the effect that for money lent, you agree to pay $300,000, written out, 300, 000 with a dollar sign. It's not 300,000 written in words, just the fictitious 300,000. Right? So for a sum of money lent, you agree to pay back $300,000, but it doesn't say how much they lent. Where did it say how much they lent you? It doesn't. And then, there's lots of wordplay goes on with this stuff. So, like debt, according to the civilians, which is civil law, that's what you're walking into. You're walking into a civil court. Debts are divided into active and passive. By the former, it is meant due to us. By the later, what we owe. So guess what? The same word has two contradictory definitions. It's either what's owed to you or what you owe somebody else, using the same word. And a debt is an obligation owned by one party to a second party. An obligation is a requirement to make some course of action, whether legal or moral. It says nothing about paying any money. It just says some course of action will take care of an obligation, and the obligation is the debt. So what's the course of action that we were supposed to take? And then please, you need to understand. You are your given name, period. That was a gift from the Creator, and you shall be known by no other. To do so is trying to make you be a person instead of a spirit-filled man. And that's slander against your character, heresy, fraud. And depending on what comes out of their mouth next, we can add to it. All penal code, criminal, well, heresy isn't, but that would be taken care of by the church. They're all penal code or common law infractions. They're violations. And how do you know that all caps is an estate and that it's your property? Well, you're the only one that can go get a damn copy of it. So if it wasn't yours, your property, then anybody could get a copy of it. All right. So, again, here's all that's in 701. The assignment not effectual, cancellation of mortgages, liens, and judgments, all the same thing, different words. We're going to talk about a title insurer, mortgage release certificate. Well, yeah, we'd like to have that, wouldn't we? The mortgage release certificate would be a wonderful thing to find. Certain cancellation, satisfaction mortgage validated. Okay, so then I went to and just started pulling stuff out of what you just saw, right, that spoke to me as I was going through it. So one of the things is, for the purpose of this subsection, the term mortgagee, them, of record. So a mortgagee of record means a person named as the mortgagee in the recorded mortgage. So someplace there is a recorded mortgage. I wonder where it is. What does record mean? Well, in Florida, because this is for Florida, means to record in the clerk of the circuit court or the comptroller. Okay? Did not say with the register of deeds in, the deed file. It said with the circuit court, clerk, or the comptroller. So the mortgage of record has been recorded with the circuit court clerk or the comptroller. It just depends on what county you're in. And that's because we have two kinds of counties running at the same time. You have ones that are, by the Constitution, and other ones that are called charter counties. And they're ruled by home rule. They're supposed to stay within the Constitution, but they get to write their own rules, so they can switch the hats of people. All right, and cancellation of mortgage, liens, and judgments. Well, that's one of the things we want to do. So within 14 days after the receipt of a request from you, the holder of the mortgage, and where are we going to find that? Well, right here. The mortgagor, the mortgage of record is who we're looking for. All right, so that's the holder of the mortgage. Shall deliver to you at the place designated in the written request an estoppel letter. Well, an estoppel letter, in my opinion, we're going to figure out is just the payment letter, setting forth the unpaid principal balance, interest due, and per diem rate. So you're going to ask the mortgagor on record, the record being with the clerk of the circuit court or the comptroller, depending on the county you're in, to send you an estoppel letter setting forth what it's going to take for you to cancel the mortgage. That sounds pretty simple. Lenders or holders of mortgages or deeds of trust often assign mortgages or deeds of trust to other lenders. That's called an assignment. Or third parties. Okay, so either they gave it to somebody else, sold it from bank to bank to bank to bank to bank, or they're giving it to a third party to hold. Third party would be somebody like the title insurance company. When this is done, the assignee, the person who received the assignment, steps in place the original lender or assigner. To effectuate an assignment, the general rules is that the assignment must be in proper written format and recorded to provide notice of the assignment. So if you're a lender, first of all, you assigned it to your lender. An assignment is just giving somebody, control over the document. It's the equitable mortgage. That's what the assignment is. I'm going to let you put this in your drawer, and now that you have it in your drawer, you have equitable mortgage / legal title over the instrument. And whatever the instrument says, the agreement, your act that you wanted to do this. Okay, if it was your free will act and deed to start with, well, your free will act and deed can be, well, I don't want to do it anymore. Okay. All right, so the mortgagee of record, who may have been assigned, it may not be the mortgagee, the bank, the lender that you had your contract with. That's why we got to go find the mortgager of record. And where is that? The clerk of the circuit court or the comptroller. Whenever the amount of money due on any mortgage, lien, or judgment shall be fully paid to the person or party entitled to payment, the mortgagee, that would be them, the creditor or the assignee, again, if they've assigned it to somebody, then it's whoever the assignee is, or the attorney on record if in case of a judgment. Okay, so this is where the attorney is getting involved, right? And again, whoever is the assignee of record will be on record with the clerk of the circuit court or the comptroller. That is where you need to go to find this information, not the register of deeds, the court, or the comptroller. And you're looking for the assignment. You're looking for, let's use their words, the mortgagee of record. That's who you're there to find. You want to find the mortgagee of record for this deed of trust. Show them a copy of your deed of trust. Okay. Where did we leave off? Okay, so yeah, I read that stuff before. So I'm going to go take that to them, and I'm going to accept their deed, bind to it, remind them they have a fiduciary duty to me, and that you're here to satisfy the mortgage. And anything they give you other than, well, here you go, and this is what you do, and you think you know, it's the confession and avoidance, you're just going to tell them, well, then you're helping to perpetrate fraud, and I'll be filing a criminal complaint against this office and have it investigated for treason against the people. There's all sorts of things they're doing wrong. I've already pointed that out in other stuff. Just look at your penal code. Whenever the amount of money due on any mortgage lien judgment shall be fully paid, okay, or the attorney of record in case of a judgment. So if you're into a judgment, there's going to be an attorney involved. Before that, it's an assignee. It could be it's the creditor. You may go find it and find out it's been assigned to us, and we just go ahead and accept it. To whom such payment may be made shall execute in writing an instrument acknowledging satisfaction of said mortgage, lien, or judgment, and have the same acknowledged or proven and duly entered of record in a book provided by law for the purposes in the proper county. Right? So if you go pay the damn thing off, they're going to execute an instrument acknowledging the satisfaction of the mortgage. It's going to be their acknowledgement that you've satisfied the mortgage, and then duly entered of the record. So now it's going to be full proof evidence. It will be a common law deed that says you're the owner of the property, because it's going to have 3 seals on it. The bank or who's ever doing it, it's going to be acknowledged, and then it's going to get another stamp from the Register of Deeds, or well, wherever the book is. They're going to know where it is. And it'll be common law. And now nobody can come and you just claim the deed of trust. You satisfied the mortgage. Now the deed of trust is yours because it was only there as a security until you took care of the mortgage. You've just taken care of the mortgage by doing whatever this is. And forget that it says money. We'll find out how much money it is when you go find the damn piece of paper. All right. That's pretty simple. And then within 60 days of the date of receipt, full payment of the mortgage, lien, or judgment, the person required to acknowledge satisfaction of the mortgage, lien, or judgment shall send or cause to be sent the recorded satisfaction to the person who has made the full payment to you. All right, so within 60 days it has to have been recorded, and they have to send it to you. In the case of a civil action arriving out of the provisions of this section, the prevailing party shall be entitled to attorney's fees and cost. So if a attorney has brought a claim against you and you're in foreclosure right now, okay, and you go and satisfy this mortgage, then there can't be a civil action anymore. Therefore, he can't prevail, which means you prevail, and you're entitled to attorney fees and cost. And leave it to the judge to determine what that is. Again, the judge and the prosecutor are not your problem. They didn't bring the claim. What we have here is in a case like this, there's an attorney on record, right? In the case of a judgment, well, whoever he is, has put up some cost and so forth, and so he is representing whoever it is your adversary is in the civil matter. But as soon as you've satisfied the mortgage, they no longer have any claim, so they can't prevail. And since that means you prevailed because they didn't, then you get attorney fees and costs, and the court's going to do the right thing and give it to you because you're going to point it out to them. But I'm not asking for money. I'm looking for attorney fees and cost, and I leave it on the honor of the court to do the right thing. All right, that's all I'd tell them. Whenever a writ of execution has been issued, okay, so a writ of execution to me is, they're going to come take your stuff, right? So whenever it's been issued, upon which, and the judgment upon which it has been issued is fully paid, it shall be the responsibility of the party receiving payment to request in writing, addressing the sheriff, return the execution as fully satisfied. So again, you're going to ask them to do this. They're going to have to write the judge, or excuse me, they're going to have to write the sheriff and say that it's been the writ has been satisfied by you taking care of the mortgage, which means in Florida, going to find the clerk of the circuit court or the comptroller and asking who the mortgagee of record is, so that you can write them to get a estoppel letter setting forth the unpaid principal balance, interest due, the per diem rate. Okay, so requests from the mortgage holder of record and a stop letter. You pay. Satisfaction of mortgage recorded. Within 60 days, copy mailed to you. Or if sheriff's sale has been scheduled, he gets a copy to show the mortgage is satisfied. Everybody's happy. All the paperwork has been retrieved and it's been satisfied, except now you have it instead of them taking your stuff. Title insurer, mortgage release certificate. Okay, well, the mortgagee is them. So they're the grantee of the mortgage. If the mortgage has been assigned of record, the last person to whom the mortgage has been assigned of record is the mortgagee. Mortgage servicer means the last person to whom you, or who's ever after you, your successor, has been instructed by them, and them is the mortgagee of record, to send payments on the loan secured by the mortgage. Okay? So you're going to have this, the mortgagee is going to have this mortgage, and it's going to be assigned to somebody, and in there they're going to say, here's what you need to pay, and here's who you pay it to, and you're going to be paying it to the mortgage servicer. A person transmitting a payoff statement is the mortgage servicer for the mortgage described in the payoff, in the payment statement. Okay, well, that's pretty simple. So the person transmitting a payoff statement is the mortgage servicer. All right, so they're going to transmit the payoff statement, which would make sense because they're the ones that you've been told to get a hold of to make the payments, and then once that's done, they're going to be transmitting the payoff to say it has been done. So maybe it's not the estoppel letter, but you get the letter first, you pay the mortgage servicer transmits a payoff statement goes to the sheriff if it's already in foreclosure, or goes to the register of deeds, either way, to tell them the mortgage has been satisfied. Okay, so what's the payoff? Well, it's the unpaid balance of a loan secured by the mortgage, including interest. It has the same definition as an estoppel letter. So who's the title insurer? Well, that means a corporation or other business entitled entity authorized and licensed to transact the business of insuring titles to interest in real property in this state under another chapter. But anyways, they can insure titles to interest, to the interest, and that's what we want. We want the interest in real property. Because on the deed of trust, not only is it the land that you're living, that you're sitting in, and you're, what you think of as your house, but your all capital letter name and those securities that you wrote are yours. So the all capital letter name is the name of your landed estate. It's real property. And the interest is the personal property within the real property. And in the real property, so in this particular case, you have a premise that has personal property in it, and it's the securities that you put up until you satisfied the mortgage. Well, when you get a certificate of release, you have satisfied the mortgage. Therefore, all those securities come back to you and all their gains. I'll say it again. All right? You go satisfy the mortgage by finding the mortgager of record and writing him a letter, and within 2 weeks you need to get a letter back stating what it's going to take to satisfy the mortgage, and you go and satisfy it, and you get a certificate of release, mortgage is satisfied, securities being any rights, title, and interest you had into the house that you're living in, plus all your securities, the deed of trust, and the promissory note, and all those payments you made, and all their gain are yours. Simply by going down to the clerk of the circuit court or the comptroller and tell him you want to satisfy the mortgage. Who's the mortgager on record? I don't think that's asking too much of you. We made it pretty damn easy. But this certificate of release, an officer so either an officer of the title insurer or a duly appointed agent. So they could, have assigned the duty to somebody else. On behalf of you or a person who acquired the mortgage, require from you the title. So either it's going to go to you or the person who got it from you because you didn't do the right steps. To all or part of the property described in the mortgage, execute a certificate of release that complies with the requirements of this section and record the certificate of release in the real property records of each county in which the mortgage is recorded. They're using the word record now instead of filed, deposited, registered. Now it's a record, right? Common law record. They're going to put a certificate of release in common law that says it is yours. Contents. A certificate of release executed under this section must contain, and then it just lists a whole bunch of stuff. You can go over on the other page. It has what they are, but really it's just saying that you've done all the things it takes to execute the frickin' deed and satisfy the mortgage and claim and probably claim the escrow. Just make sure you're asking that. Well, then you have execution. A certificate of release authorized by subsection 2 must be duly executed, sworn or affirmed under penalty of perjury. So not only do they have to put a piece of paper, and it has to be under penalty of perjury. They never put anything under penalty of perjury. Do you understand how big this is? They're going to put under penalty of perjury. It's your frickin' property. And that can be done by an officer of the title insurer or, guess what, a duly appointed agent of the title insurer. I wonder who that might be. So who might be their agent? The appointment of an agent must be duly executed, acknowledged, and recorded by an officer of the title insurance and must state a separate appointment of agent shall not be necessary for each certificate of release, provided that at least one such appointment is recorded in the county in which the mortgage property is located. Well, first of all, what did they say? It says the title insurer can appoint an agent. And to do that, they have to put in a letter of appointment and have it recorded. Duly executed, acknowledged, and recorded. Common law, it's going to say this is the people that can do this for us. And that has to be recorded in the county. So who's your title insurer? Right? Who's the title insurer? And they have to have appointed somebody. Well, I think the person they've appointed is going to end up being the mortgage servicer. The last person to whom a successor in interest has been instructed by them to send payments on a loan secured by a mortgage. It just makes sense. It's all going to happen in the court. You're really not going to have to go anywhere. The paperwork's already there. You're the owner of the frickin' property. You just need to go and satisfy the mortgage. But regardless, they have to have an appointment of the agent. So you could call them and say, who is your appointed agent? You could call your title insurer. I need to know your appointed agent in this county. Or you can go to the court and see if it's them. So what's the effect when you've done all this? Well, for the purposes of releasing a mortgage, a certificate of release containing the information statements provided in the subsections above is entitled to be recorded. Again, recorded now. We're not talking deposit file, registered. Now we're using recorded. Wonderful word for us. With the county recorder, and operates as a release of mortgage described in the certificate of release. Oh, well, now all of a sudden the county recorder's involved. Now I don't know if that's who the register of deeds is or not. In Michigan we have a register of deeds. If Florida has a county recorder, that's who they're talking about. But if the office isn't called, you're going to the office that says county recorder and you're asking specific questions. But it looks like when this is done, you're going to take it over to the county recorder, and the county recorder shall rely on the certificate of release, the mortgage. All right, so I'm just throwing words together now. So an estoppel letter, right? Unpaid principals, balance, interest due. Well, it's the same as a payoff statement. Unpaid balance. Okay, so to me, it's kind of the same thing. The person transmitting a payoff statement is the mortgage servicer, right? And that equals, well, mortgage servicer means last person that you're supposed to send the payments to. All right? So that will be on the mortgage the mortgage of record, because it's supposed to say in there who you're supposed to make the payments to. So the title insurer means corporation or other entity authorized. So it's either the corporation or they're going to authorize somebody. And a certificate of lease comes from the duly appointed agent of the title insurer on behalf of you. Or if you don't do it, the guy that's going to get your property because you won't go down and do this. Execute a certificate of release that complies with the requirements of this section and record the certificate of release in the real property records of each county in which the mortgage is recorded. So you want to find out how many different counties this thing is recorded in. Because if your body's involved in this, your all capital letter name, landed estate, and the account number is your premise, it's your personal property, and that's the other part of the security that you've put up. You've put up some of your premise as security until you satisfy the mortgage. All those records may be in your birth county because that land has never left the county, in my opinion. If a satisfaction or release of mortgage has not been executed and recorded after the date payment in full of the loan secured by the mortgage has been made in accordance with the payoff statement furnished by them or the mortgage servicer, a certificate of release authorized on that other section must be duly executed, sworn, and affirmed under penalty of perjury before a notary public and recorded, and may be executed by an officer of the title insurer or duly appointed agent. Okay? A separate appointment of the agent shall not be necessary. Okay, so they don't need to have one for everyone, but someplace they have one, and it will be recorded in the county. And again, in this section, a set of record was with the circuit court clerk or the comptroller is going to say who is the designee for the title company, right? Because it's going to say who the agent is that you can work with. And when you're all done, the county recorder shall rely on the certificate of release to the mortgage. Well, they're going to rely on it to say the mortgage has been satisfied. And now your escrow can be released. All right, so here is the final analysis. All right, and really this is just, I'm going to go over it one more time, right? So there's a thing called an estoppel letter, and there's a thing called a payoff statement, and they both mean the same thing. There is a person called the mortgage servicer, and he is on the payoff statement, or he is going to transmit the payoff statement. And the mortgage servicer is the last person you've been told to send the payments to. Okay, and that's going to be on the payoff statement. And And the title insurer, well, we know what that means. And they're going to give you a certificate of release after either them or a duly appointed agent of the title insurer on your behalf is going to issue a certificate of release in due form of law that says you've satisfied the mortgage. I wish I would have copied more of this, but all this is in the original thing, right? So you go read the damn statute yourself. If a satisfaction release of mortgage has not been executed and recorded after the date payment in full of the loan secured by the mortgage has or was made in accordance with the payoff statement furnished by them or the mortgage servicer. Everything starts with that frickin' file, the assignment file, that's either with the clerk of the court, apparently, or the comptroller. And just, don't take no for an answer. If you're in Florida, all you need to do is print out these statutes and go highlight the parts that you need to know when you walk in there and say, well, according to this, you're supposed to do this. This is why I'm here. And if they refuse to, you say, well, on and for the record, I accept your oath. I bind you to it, remind you of fiduciary duty to me, and I'll extend you my sovereign immunity. But if you're going to impede my my lawful process, I might put in a criminal complaint against this office. So why don't you go talk to somebody first before you make that decision, sister? Because I'm leaving here today, the owner of this property. Okay, and so the clerk of the circuit court or the comptroller. That's where it starts with. That's where the mortgager on record will be found. And from that, we start going through the other pieces of paper, but there aren't that many. All right? Look at that. When you get down to it, that's all there is. You got to get the estoppel letter and figure out from that who the person is you're supposed to pay. And then you're going to get a certificate of release either from the title insurer or the duly appointed agent. And, that's all been put on record. So where's the record? Well, we saw in this one here, any, definition of record in this section. Record with the circuit court clerk, the clerk of the circuit court, or the comptroller. Right? That's where the mortgager of record, or the mortgagee of record, is supposed to be, and it's the last person it was assigned to. I know I'm driving that nail hard, but, it's that frickin' simple. Now look at this is for Florida. It's going to be the same in all states, only different because they're going to use different words, different names for offices. The hats are going to be slightly different. But if you go to, if you go to your state legislature site and find the statutes and you put in things like assignment of mortgages, cancellation of mortgages, just mortgages, and see what words they use, and then, okay, well, we're using satisfaction instead of cancellation. Okay, well, what's it say to do to satisfy it? They're using words that have similar meanings, they're just different words. But the definitions are the same. And all that is everything you need to know to cancel a frickin' mortgage on your house in Florida is in Chapter 701. And this is the whole thing. This is how long it is. All right? It ain't that many pages long. So if you don't get it the first time, well, fucking read it again. And then go read it again and then again. Until you understand. Go look up the damn words. Okay, get off my soapbox. I'll leave it there. You all have a great day. I'll be posting this. We'll see if this one works. See ya.